Welcome again to the Melling Law YouTube channel. Today we're going to talk about choosing a Utah trust. I get a lot of questions about what kind of trust do I need from clients, and it's frankly something that people really don't know much about. They've heard, oh, well, you need a trust for this or that, but they really don't know what kinds of trusts are out there or which one's going to be appropriate for them. There are three basic trust types or families that I'm going to talk about today. Most trusts fall under either the testamentary category, so that's something in your will. There are also living or revocable trusts or revocable trusts, depending on how you want to pronounce it. And then there are irrevocable trusts. So those testamentary trusts, the word testamentary, it comes from your last will and testament. It's something that you write in your will. So because of that, there's no initial setup. You don't need to do anything other than include the trust provisions in your will itself. Because of that, it's formed later as part of the process of probating your estate. So after you die, then your personal representative will go over your will and say, oh, look, this person wanted to set up a trust with the estate's assets, so we'll go ahead and set it up now. That way there's not a lot of upfront cost, but it is subject to the probate delays and costs. So generally, I mean, you're going to pay about the same amount. It's just whether you want to do it up front or on the back end, and whether you want to subject your beneficiaries to those delays. For most people, especially those looking to take care of minor children, usually will recommend something like a revocable or living trust. That's a little bit different. It's formed during your lifetime and controlled by you during your lifetime. But after you pass away, then it's controlled by whoever you want to control the assets in the trust. The advantage there is that it avoids probate. Usually with probate, in Utah, you're looking at a fee of $360 just to file for probate, and then another publication fee, sometimes several $100s, and a delay period. So you're looking at minimum $1,000 plus attorney fees, plus the 3 to 9 month, sometimes more, delay in probate. And if you've got minor kids you want to take care of, that's not an ideal option. So these revocable living trusts help you avoid that. And it also, if you own property in multiple states, that property has to be probated in multiple states. Now, if you have it all in a revocable trust, and if that state's law allows you to do things like this, then you don't have to deal with probate in any of the states where you own property. Finally, it's revocable trusts are considered part of your estate for tax purposes, so you have a pretty high exemption where you can give away property in your estate up to $5.5 million, just about. In Utah, because we don't have a state level estate tax, revocable trusts are a nice way to pass on property without tax consequences. One of the drawbacks of revocable trusts is that there is no creditor protection. So if you file bankruptcy, or if there's a judgment against you, say you hit someone in your car or something like that, those trust assets will probably be subject to that judgment or that bankruptcy. Now, the last major family of trusts are the irrevocable trusts, and there are a lot of subcategories that I'll go into in a minute. But those irrevocable trusts have a few general qualities, such as they need an independent trustee, so not you, usually not your spouse or your kids or someone really closely related to. For most of those irrevocable trusts, in order to accomplish the goals that they're set up for, you want someone independent, maybe a family friend, or someone who's got complete discretion over the trust assets within the parameters that you set. You've also got, it's an irrevocable transfer of assets, so you can't say, oh, well, I want these things back because it's irrevocable. So the trustee could give them back to you. They may have discretion to do that, but it can't be something that you can take back on demand. They're not considered part of the estate for tax purposes, so there may be other taxes that come up, but generally these irrevocable trusts will fall outside of the estate tax if you're dealing with a larger estate. Now transfers, anything you transfer into the trust is usually subject to capital gains. So let's say you bought a farm for $1 million and you want to put it in an irrevocable trust and it's now worth $2 million. You might have to pay gains on that difference, capital gains, upon transfer into the trust. Finally, trusts, these irrevocable trusts are subject to a trust income tax. It can be pretty high. So if it is kind of an income generating property or assets like investments that might increase, there might be huge tax consequences there. So there are a lot of downsides to these types of trusts, but they do have their place. There are three major places where they come in. One is for asset protection trusts. If you've got maybe a high-risk profession, you're a doctor, or maybe someone who deals with construction, or you're worried about liability in any way. In 2013, the Utah legislature revised our asset protection trust code, gave you a lot more protection from these creditors, but there's a lot more responsibility. There are a lot of things you need to check to make sure that a judge who is reviewing a case against you will be able to say, yeah, these assets are protected. So a lot of those fall under some of the things we covered in the last slide. There are a few other things that come into that, and so it may or may not work for some people. A lot of times you'll have trust mills or other professionals try to sell people on these types of trusts, but they really do need to be done properly, and there are a lot of downsides. So it's really a give and take. So you really want to talk to an expert about asset protection. The same thing goes for special needs trusts. This is something you really want an expert to deal with. They're a little bit better than the new 529A plans that allow you to take care of someone and provide for someone who's on Social Security disability without counting against their assets. But those 529As are subject to recovery, whereas special needs trusts can go to remainder beneficiaries like other children or other grandchildren or whoever you would want to go to. Finally, one of the other ones that comes up a lot as far as irrevocable trusts are concerned are these irrevocable life insurance trusts, ILITs. If you talk to a lot of accountants or finance professionals, they'll call them ILITs. These are a lot less common now due to the high estate tax exemptions that we have, where, if you've got a married couple, their estate can pass on almost $11 million tax-free. Back when that number was closer to 600,000, these irrevocable life insurance trusts were a way to keep life insurance out of the estate and make sure that it passed tax-free to beneficiaries. Nowadays, it's a little less common, but they do still come up, and so I thought I'd mention them. They're subject to a lot of these other things that the other trusts are subject to, but they're a little more lax. And then there are several other types of irrevocable trusts, especially for high net worth individuals. You're talking estates over $5 or $10 million. But these three are the ones that really come up often. And any time you're doing an irrevocable transfer, you really want someone who deals in just estate planning matters and really focuses on just that, making sure that they are on top of things and up to date with the latest code changes. Because it is an irrevocable transfer, you just want to make sure it's done right. If you have any questions at any time, you can call us here at Melling Law at 435-572-0807, or you can contact me personally at tyler@mellinglaw.com.